All right, ladies and gentlemen, welcome back here to the full story on WYAB 103.9. My name is Matthew Bishop. And yesterday we talked about the Tulsa shooting in length, and a lot of people did not agree with me when it comes to defending the Tulsa police officer. Well, today, prosecutors charged the Oklahoma police officer with first-degree manslaughter, which is less than a week after she fatally shot the unarmed black man on the city streets, and just days after police released a video that we talked about yesterday as well. Tulsa County District Attorney Steve Kunzweiler charged Tulsa officer Betty Shelby in the shooting of 40-year-old Terence Crutcher, and he said that arrangements are being made for her surrender, so they haven't quite got her in custody yet, but I'm sure she will voluntarily give up. According to the affidavit with the charge, it said that Shelby reacted unreasonably by escalating the situation from a confrontation with Mr. Crutcher, who was not responding to verbal commands and was walking away with her with his hands held up, became emotionally involved to the point that she overreacted. And that is according to the affidavit with the charge. Okay, so for those of you who don't know, I went to law school, and I've worked for the U.S. Attorney's Office and the Army JAG Corps. I've been around criminal law quite a bit, and I've seen quite a lot of different crimes. And so I pulled up the statutes here of all the different of all the things she was charged, and I think I'd act as her defense attorney, and how I could get her off, or at least get one person on the jury. Like I said, to be convicted in this system, in our system, all of the jurors have to find you guilty. If you have one that disagrees, you have a hung jury, which is kind of a win for a defendant. It may be recharged, but oftentimes they're not. So I pulled it up, and the Oklahoma statute for manslaughter in the first degree is Oklahoma citation 21711. That's section 21711, amended in 2014. And what they're charging under is paragraph 2 of that statute, and it says, a person is, homicide is manslaughter in the first degree when perpetrated without design to effect death and in a heat of passion, but in a cruel and unusual manner, or by means of a dangerous weapon, unless it is committed under such circumstances as constitute excusable or justifiable homicide. Now that last part is very important, okay? Unless it is an excusable or justifiable homicide, okay? She obviously met the first elements there. It was cruel and unusual, was the gun. It was had with a dangerous weapon. She did shoot him with the gun, so she undoubtedly had that, and she shot him to effect death. Because she shot him center mass, she was trying to kill him. That's no doubt. So she meets the first elements of that, the first two elements, affecting death and with a dangerous weapon. Now she'd be guilty unless it was under circumstances of excusable or justifiable homicide. Now all of this, remember, and this is according to Oklahoma Statute 21693, it has to be beyond a reasonable doubt. So all of these elements has to be beyond a reasonable doubt. Okay, that means that's the highest level of proof for a prosecutor. It's not just she may have, she may not. No, it has to be beyond a reasonable doubt. Now that's just reasonable doubt. That's no doubt. It's just reasonable doubt. But it's more than just she may or may not have done it. I'm 50% sure. That's not unreasonable doubt. Okay. So I looked up, and I looked up justifiable homicide by officer. So there's two ways she can get out of this. Okay, one is 21732, which is justifiable homicide by an officer, and 21733, which is justifiable homicide by any person. So she was an officer, she was a peace officer, and she of course is any other person. All right. So it says here, a peace officer, correctional officer, or any person acting by his command in his aid and assistance is justified in using deadly force when, and I'm going to jump down here to, there's about 4 different paragraphs, but the paragraph I think applies to this case is paragraph 3. And it says it is justified when the officer is in the performance of his legal duty. She was in his legal duty. She was pulled in, but she saw a man on the side. She was doing her legal duty, or the execution of legal process, and reasonably believes the use of the force is necessary to protect himself or others from the infliction of serious bodily harm. Now this is where I think she has a very good case. Because we have to look at it, remember, we're looking at it through her eyes, okay? We're looking at it through her eyes if it was necessary. Alright? So, according to her testimony, and I'm sure they'll call her to the stand, I would definitely call it, she's a police officer, she's probably a very good witness. It says, she reasonably believes the use of the force is necessary to protect himself, okay? So according to what we know, and according to the affidavit itself says that he wasn't following directions, okay? And then according to her testimony, I'm sure she'll testify, that she saw him either reaching into the car or reaching into his pocket, And she thought, and I think it'd be reasonable, because we had another officer deploy his taser. All right, so we know that officer was thinking he may have been doing something too. We know he wasn't following instructions. We have another officer pulling his taser out on him, okay? And then we have her actually shooting him. So we have the guy with the taser, and she's shooting him because she thinks that he may be pulling something out of his jacket or pulling something out of his car or whatever. We know he had baggy pants on. We know he wasn't following instructions. We know he was walking back to his car. All right, we add all of those together, and I think at least I can get one juror on that jury. I don't know what the jury size in Oklahoma is, but in Mississippi it's 12. If I can get one person on there to think that I'm trying to put that juror in her place. I'm trying to put all the jurors through her eyes. I'm trying to put them in her place. It's hard to do because not a lot of jurors are police officers, okay? But we have, we see a lot of these black criminals beating on female officers a lot. We see that in the news. We've seen videos of that. So she's thinking about that. We're thinking about it through her eyes, remember? So she's thinking about that. She's thinking that this guy, he's acting kind of funny. He's not following directions. I don't know what he's doing. He's reaching into his car. He may be pulling out something. I don't know what he's pulling out. All right, so I have an instant to react, okay? If I don't react and it's a gun, he can shoot me or my partner. All right, so that's what I'm thinking. All right, and so I am reasonably believing, I think any other person would reasonably think that he may be doing something, okay? And so I pull up my gun and I shoot him because I think he is trying to pull something out and shoot me or shoot my partner. And that is reasonably necessary to protect myself. Okay, it's reasonably necessary to use deadly force to protect myself. I think he has a deadly weapon. All right, and I think it's reasonable to believe that he had a deadly weapon because he was reaching. He was being kind of funny. Okay, we saw him backing up. He's doing a lot of funny things going on. All right, and so we see that, and I think it is reasonable for her to believe that he was reaching in for a gun. All right, so that's 21-732. That's only from a peace officer point of view. Okay. And then we have 21-733, the very next statute. Now I'm looking at paragraph 2. Now it says that a homicide is also justified when committed by any person, when committed in lawful defense of such person or another, when the person using force reasonably believes such force is necessary to prevent death or great bodily harm to himself or herself or another, or to terminate or to prevent the commission of a forcible felony. This goes right back to my same defense, okay? Just as she would as a police officer reasonably believe he would do it, as a regular person. If I got some black guy and he's or any kind of person, and he's doing funny things and he's pulling out, whatever, I'm kind of nervous. Okay, she's pulling up on this guy. She don't know what's going on. We just see some random car in the street. All right, she don't know what's going on, what this guy's story is. We know he had drugs in his car. We don't know if drugs were in his system yet. That's still to be determined, but that's definitely going to be in her trial. Okay. And so if that comes out, he may have been on drugs. She didn't know that. Maybe she knew he was acting funny, and so she reasonably believed he was a danger to her or to her partner. We know there's a partner next to her. He's the one who pulled out the taser, and he thought it was necessary to institute force against this guy because he was acting funny. And so I think, if we're just going through the statute, now, a little caveat, like I said, law school screws up your mind a little bit, okay? We think a little different after law school, all right? Because we don't look at things like a normal person would. We look at these things and look at how can we get our client, in this case, if my client is her, how can I get her off of this? And I think she has a great case here to get off based on either of these two statutes. You may disagree. I would like to take your calls and see her, but we only have a 30-minute show today. But I think she has a great case here in trying to get off on either 21-733 or 21-732. Because we have to look at it through her eyes. Like I said, it's always easy. We see the video camera. We see it from the bird's eye view. It's easy to judge her from that. And the jury's going to see that too. All right, but this is why we have a jury system. This is why our system is the best. Okay? It's because we have only a jury of your peers can convict you. The government cannot convict you. We saw a great example of that in Baltimore. How the government so badly wanted to convict those police officers, but they were acquitted because of our great system. As bad as the government wanted to convict them, they were taken off. The same thing with Zimmerman. Everybody, the media, all wanted this guy convicted, but the facts showed otherwise. And our system works. All right, it works most times, okay? It doesn't work all the time. Sure, guilty people get off. But I think sometimes, with some guilty people getting off, it's worth it because of how great our system is. Because we don't have very few, much less innocent people being found guilty. And one thing I worry about these things is, one thing I always worry about is that we kind of go into mob rule, and that these district attorneys succumb to the mob rule, and that's definitely not what we want.